Morning. Before we begin, I would like to acknowledge that we meet and we learn from each other today on country. I'm coming to you from quite a young library, which sits on one of the world's great ancient libraries, a rich repository of oral tradition. I am on Gadigal land, where I live, work, and write, and I pay my sincere respects to elders past and present, and I extend that respect to any Aboriginal and Torres Strait Islander peoples here with us this morning for what is the last Scholar Talk for 2024. So the year has absolutely sped past. It seems like only the other day I was introducing Dr. Effie Karageorgios and our first Scholar Talk for this year's season. For those of you who don't know me, my name is Rachel Franks. I'm the coordinator of scholarship here at the library, looking after the library's ever expanding, it seems, fellowship program with people doing research on such a wide variety of things and bringing our collections to life. Today is all about Dr. Peter Gibson, who is our 2023 Hertzberg Fellow. He's going to be talking about the New South Wales Factories and Shops Act, which was actually the first industrial instrument for the colony, now state. If you have any questions of Peter after his presentation today, please use the chat feature in Zoom, and I'll be back in a little while to ask those questions. Thanks so much, Peter.
Oh, thanks, Rachel, and thanks everybody for coming to my talk. Let me just share my screen and we'll get started. Okay, so I'll be talking about the Factories and Shops Act of New South Wales. And I get to know something about this subject, and I became interested in it as a result of my PhD research at the University of Wollongong between 2015 and 2019. So I looked in my PhD at a specific activity carried on by Chinese migrants, mainly in Sydney and Melbourne, and that was furniture production. So, for various reasons, largely after the mid-19th century gold rushes, many many migrants and their descendants established furniture factories and were subject to the Factories and Shops Act for this reason. So I've written quite a lot about the legislation and its counterpart in Victoria in this respect, and I'll touch on some of that again here. But I decided to do further research on this law because it was much, much bigger than just Chinese furniture factories. So it was, in fact, New South Wales's first industrial legislation covering Australia's foremost industrial centre, Sydney, and then gradually other New South Wales industrial hubs, namely Newcastle and Broken Hill, but still mostly concentrated on Sydney. So there is remarkably little prior research on this subject, and I thought that it deserved more attention, and particularly given that Victoria's Factories and Shops Act, also of 1986, has been the focus of extensive investigation by historians, including Marilyn Lake. And this is because of its groundbreaking minimum wage clauses, which weren't seen in New South Wales. So the main thrust of the New South Wales Factories and Shops Act related to incidents like that associated with Barker and Co. mills. Barker and Co.'s was Australia's and indeed the Southern Hemisphere's biggest wool spinning operation. So it burned down in 1872. And apparently the floorboards had absorbed so much oil from the wool that the mills virtually exploded when the fires started. Fortunately, there were no employees there at the time in the early hours of the morning. But this kind of conflagration was far from unusual in industrial operations. So the cause here was unclear, but it was often the case that steam boilers malfunctioned and regularly killing workers in the process. So the machinery powered using the boilers was also extremely dangerous to factory workers in most instances, including the various machines like carding machines and so on here used here to produce processed wool. So, along with issues of safety in this relatively new Australian industrial landscape, many workers in Sydney are worried about so-called cheap labour. So, in particular, Chinese workers caused consternation among workers of mostly British origin, certainly within the furniture industry, where they were already working, but also much more broadly for fear that they'd replicate these efforts in other industries. So many factory workers thus felt that they needed legislative protection. And part of that was a legislated minimum or living wage. So the first formal effort I've seen to get an industrial law enacted um, um, in New South Wales is here. So this is an excerpt from 1884 from the Minute Book of the Parliamentary Committee of the Trades and Labour Council of New South Wales. So this committee later went on to become the Australian Labor Party. So it relates to so-called land boilers. So that is factory boilers, which regularly malfunctioned and typically exploded. So the committee member Ramsay McKillop here he instructed that a law to regulate boiler usage be taken up with one Jacob Garrard. Both men were key Labor activists, and Garrard was elected to Parliament in 1880. This notion for boiler regulation was soon developed into a bill for factory safety in 1885, but the bill failed. So part of the reason was that the New South Wales Parliament rarely intervened in the market. So the Labor movement had much more success in Victoria, though, where the idea of protecting local industry through legislation appealed much more to parliamentarians than it did in New South Wales. Nevertheless, there were several developments in the late 1880s and early 1890s that changed the New South Wales political environment. Significantly, there was a large recession during the 1890s. So this precipitated mass unemployment and labour unrest and consequently increased labour movement influence. There was also an upsurge in anti-Chinese agitation, resulting in the 1888 Chinese Restriction and Regulation Act, as well as a royal commission into the affairs of Sydney's Chinese community in 1891. The Trades and Labour Council of New South Wales played a central role in both of these. And these events led to a new, much stronger bid for an industrial law in 1896. This excerpt here comes from the 1896 annual report of the New South Wales Chamber of Manufacturers. It states that the Chamber, the Association of Manufacturers in New South Wales, was in no way opposed to legislation against sweating in factories. So that is grueling working hours and poor conditions. Rather, industrialists opposed so-called socialistic regulations. So the report's two main authors, the President Charles Hoskins and the Treasurer David Davis, quoted Robert Burns here to stress their distaste for inhumanity in industry. So their idea of socialistic legislation seems to have related to what they saw as unnecessary government involvement in their activities. So that is industrial legislation that went beyond the protection of the most vulnerable workers. So this included the provision for the minimum wage proposed by the Labour Council in 1896. As in principle, manufacturers supported regulation of factory safety and working hours. It's interesting, though, that the chamber was formed in 1885 in answer to the Trades and Labour Council's first bid for industrial legislation, and then it was disbanded, and then it was revived again in 1895 in time for this second bid. So it would certainly appear that it really only existed to oppose legislation in relation to industrial manufacturing. A compromise of sorts was reached, however, and the 1896 Factories and Shops Bill became the Factories and Shops Act on the 17th of November 1896. I am, of course, really condensing here what was a long and complex process involving numerous parties to produce this law, but I think this overview is sufficient for our purposes. The resultant act required the creation of a factory inspectorate, associated records, measures for health and safety, measures against child labour, including in shops as well as factories. And it also specified penalties for violations. So it was a fairly sizable document at 14 pages and a number of clauses in each of these parts. The vast bulk of these, though, were in sections 3 on sanitary and health provisions, and section 4 on machine fencing and guards and fire safety. Section 3 of the Act required clean walls, adequate lavatories, dining areas, ventilation, seats for women, and exclusion of workers with infectious diseases from working in factories. So Section 4 stated that employers were liable for injuries from steam boilers, that machinery be fitted with fencing and guards, that pulleys and hoists be secured, and that means of extinguishing and escaping fire be provided in factories. Section 4 also very significantly prohibited the employment of children under the age of 13 years, under the age of 13 in factories. So notably, all these provisions applied only to establishments of 4 or more people engaged in manufacturing, but any establishment with Chinese workers was considered a factory as well. So indeed, Chinese factories were subject to more scrutiny overall. This act was the New South Wales Parliament's first major intervention into what was Australia's freest market. So there was no clause, though, for a minimum wage and none for stamping of Chinese-made furniture, and both of these clauses were included in the Victorian Factories and Shops Act of the same year. Nevertheless, this law was indeed, for its era and location in New South Wales, very much a socialistic law, I think. So 3 factory inspectors were appointed initially, one of whom here was Annie Duncan, and her focus was on industries with mainly women workers, like the clothing industry, for instance. So she was born in Adelaide and trained and worked as a factory inspector in London, and then relocated to Sydney in 1897 when the Act came into operation. So part of the work of inspectors was to see that factories were registered and that they provided information about their employees and other aspects like their machine usage. So this information was then compiled into a yearly set of a really quite comprehensive data about manufacturing in Sydney and eventually other parts of New South Wales. So this data was used in policy making for decades, including in subsequent amendments to the Factories and Shops Act of 1896. So I've just pictured here in the middle one of the numerous tables of rich information that makes up the yearly factory inspectors report. So the reports also specified how implementation of the law progressed as the factory inspectors saw it. And as I mentioned, the bulk of the legislation dealt with health and safety. That's the third part of the act. So one of the key issues for inspectors covered under Part 3 was ventilation. So this photo shows a fluff extraction system and a diagram below shows how it was designed. And this was intended to minimize the quantities of textile fibers breathed in by workers. So the condition resulting from overexposure to these fibers was known as the brown lung or mill fever. And my apologies for the quality of these factory photos. So I took these directly from the inspector's reports, and the quality isn't very good. I wasn't able to find the negatives in the library catalogue or New South Wales state records, unfortunately, but I'm sure they're there among thousands of photos processed by the government printing office in this era. These pictures are enough, though, I think, to get a sense of what the legislation meant. So certainly by 1909, so after 13 years of the Act, clear progress had been made here. Earlier descriptions of related issues in factories suggest a much grimmer picture. So black flock, another kind of textile product, for example, was regularly detailed by factory inspectors in reports and labour activists in their meetings and also in the press. The black flock was a waste product used to stuff furniture and mattresses, and it was made by shredding discarded cloth. So it posed a danger of both the brown lung from the fibres and also infectious disease from garbage where it originated. And it was often prepared in poorly ventilated spaces, typically by women and children. Even so, we should, I think, see these photos as models rather than representative samples of what factories were like, even in 1909. Since cases of Hessian bag factories and the like without appropriate ventilation were still common in this period. So here's a photo of a dining room in a tobacco factory. I should mention at this point that all factories mentioned in the factory inspectors' reports were anonymised, so it's not possible to identify where they were or who owned the factories. So this unspecified tobacco factory shows the importance that was attached to separating dining and workspaces under Part 3 of the Factories and Shops Act as well. So standard practice had often been for workers to eat at their workstations. So even in the early 20th century, tobacco companies were adding toxic chemicals to tobacco. So this was dangerous for workers. In other factories, the risk of harm was perhaps more immediate, such as through the ingestion of metal shards, for example, in steel mills. So another focal point of the Act and the inspectors working to enforce it was ensuring that dining areas were sufficiently separate from lavatories. So there were some cases where inspectors observed that factory proprietors had failed to make arrangements in this regard, and forcing workers from factory floors into lavatory areas for meal breaks. And this is the same tobacco factory pictured again. Here we see what factory inspectors described as its roofed rest gardens. So this photo is an excellent illustration, I think, of of another phenomenon that the factory inspectors regularly recorded, and that is surprisingly enthusiastic compliance with the Act's provision by factory proprietors. So here it's not hard to imagine that the rooftop rest area would have been the ideal place for workers to smoke tobacco that they'd bought in the factory, with perfect ventilation and complete separation from workspaces and lavatories. There were similar instances. The factory inspector, Mr. Armitage, recorded in 1898 that one industrialist, on seeing his workers were less lethargic and more productive with additional ventilation at one of his factories, had made a substantial investment in improving in ventilation across the entirety of his operations. So this goes some way to explaining why the Trades and Labour Council and the Chamber of Manufacturers were able to agree on what might have been seen as socialistic regulations. Part four of the Factories and Shops Act covered fire safety. So here are a couple of external fire escapes. So the second shows what appears to be the whole workforce using the fire escape, which seems dangerous, but would have been the reality in a factory fire. So good to know that it could hold the whole workforce. Certainly, factories are very dangerous in terms of fire, especially before electricity, when steam boilers were the main source of machine power and kerosene lanterns were the main source of lighting. So factory inspectors did indeed order elaborate multi-story fire escapes like these on some of the largest factories, and were very proud of their efforts in that regard. But their principal challenge here was to try to ensure factory operators kept emergency exits unlocked. So there was one case in 1899 where a factory boss um, had a suitable door for escape in the event of fire in the factory, but he was adamant that it stay locked to prevent workers from sneaking out to drink at the nearby pub. So he implored the inspectors to allow him to keep it locked for this reason, but they refused. There was a similar case in 1901. A factory boss had installed new toilet cubicles, and he was becoming increasingly frustrated that his men were sneaking away to the toilets to drink. So rather than lock the toilets, however, he consulted with Inspector Taylor about what to do. And the inspector advised him that he shouldn't have taken the cubicle doors all the way down to the floor, that he should have left a gap at the bottom narrow enough to preserve the modesty of the user, but wide enough to check that workers weren't loafing in there. And this would have the extra benefit, the inspector argued, of making the lavatories easier to clean. Much of the Act, and thus inspectors' time, was also focused on machine guards, so especially on what were called spur wheels. So we can see here that the teeth or spurs of the wheels on these machines are covered in metal casings or guards. So the danger with uncovered spur wheels was not that they'd injure a finger or perhaps an arm. Rather, it was common for factory workers' clothes to be caught in them, and then workers would be completely dragged up into the machinery. The factory inspectors had to attend scenes of such accidents regularly, and indeed there are some harrowing descriptions of these in their reports. So guards like those pictured here made this much less likely, and understandably, inspectors appear to have placed a particular emphasis on seeing these guards installed on spur wheels. So there are several descriptions of factory bosses resisting installation of such guards after installing new machinery because of the additional cost needed, but then doing so immediately and impeccably and at far greater expense than necessary after witnessing an accident at their factories as a result of the failure to install guards. Similarly, here we can see a fence around an engine operating as steelworks. So fencing complemented guards. We can also see off switches on the wall nearby, which was another safety measure if someone were to get caught. Inspectors regularly noted that the excessive noise in engine rooms, such as this one, which were particularly loud even by late 19th and early 20th century factory standards. The Factories and Shops Act, however, did not have provisions for hearing protection, and besides, the subject was not well understood in this period, so nothing was done. Inspectors often did take it upon themselves, though, to do more than the act required. The provisions for guards, for example, were never really that specific in the act, meaning that the inspectors could have enforced it without so much work, but they did that work anyway. Now here we see more machine guard, this time for furniture factory machinery. We see here in the diagram of the bandsaw guards that the most dangerous part was not the blade, but the guide wheels that moved the blade. So these smaller wheels were less dangerous than the larger spur wheels from the earlier photo. Nonetheless, they certainly still caused horrific injuries and deaths. So the guard on the circular saw, on the other hand, does cover the blade. So circular saws were and are notorious for what's called kickback. So where the timber being cut is kicked back at the operator or elsewhere, possibly at a factory co-worker. So kickbacks, as well as shooting timber across factories, also led to limbs being lost. So these were the most numerous injuries in the furniture industry, where the kickback resulted also in the work of falling onto the blade. And this was before the widespread rollout of the guard in this period, which, according to factory inspectors, drastically almost eliminated this kind of circular saw accident. We can also see here some more extractors here in this furniture factory, this time for sawdust rather than textile fibers. So here's a photo of a boot factory. We can see similar guards and extractors here. The main reason I wanted to show this, though, was the age of the boys working in the factory. They look to me that they're just about exactly 13 years old, too young, possibly, to be operating this guarded but still very dangerous machinery. Still, the Factories and Shops Act prevented children under the age of 13 working in factories. So this actually represents a progress. Inspectors did stop a number of children under the age of 13 working in factories. So there was one case in 1897, for example, where a factory proprietor had locked up his employees, including many young children, in the factory all night because they had not met their production targets the previous day. And I was glad to read too that Inspector Taylor cited that particular boss under multiple provisions of the Act. We might suggest that the Factories and Shops Act was progressive, if not for the anti-Chinese clauses that I mentioned earlier. So any place where a Chinese workers manufactured items was considered a factory and therefore subject to all of the Act's provisions. For other operations, though, there needed to be four people, meaning that small-time non-Chinese manufacturers didn't have to comply. So R. Wong's furniture factory here would have been covered anyway because he had a relatively large workforce. But it meant that the smallest operations needed to navigate regulations that their non-Chinese counterparts didn't, which placed them at a distinct disadvantage. So the smallest Chinese factories, and as I mentioned, these are almost exclusively furniture factories. They tried to be self-sufficient by keeping chickens and ducks in factory yards, for example, which frustrated factory inspectors seeking to enforce sanitary clauses. Small-time operators weren't very well positioned either to know that they were subject to this legislation. So inspectors did run ads in Chinese language newspapers, but such operators weren't necessarily literate. The outcome was that frequently, and certainly in the Act's early years, factory inspectors went to Chinese factories, and the occupants didn't know what was happening. So often inspectors called the police to force their way into Chinese factories to conduct their inspections. So in 1909 too, the Factories and Shops Act was amended to limit working hours in Chinese factories and also factory dormitories, which was standard practice for Chinese manufacturers. But this meant that factory inspectors began uh, creeping around during the night, listening for sounds of work, and also entering the Chinese factories at night, trying to check whether workers were sleeping there. I think this it really problematizes the progressive narrative that I've constructed here thus far. Perhaps not quite to the point that it negates inspectors rescuing young children from other factories, but certainly I think to the point where we wouldn't celebrate the Factories and Shops Act as a win for workers. And 1912, the Act was replaced. Essentially, it was a consolidation of the previous amendment, along with a new minimum wage act that was passed in 1908, and after that was progressively amended a number of times, notably also in 1927 when further anti-Chinese provisions were inserted. And I think that's all for my presentation. I don't know how we're going for time, but I'm happy to take any questions now if there are any.
Thanks so much, Peter. We do have quite a few questions coming through, so good
Okay,
timing. Although I am quite
okay.
concerned now. I'm going to keep looking at all the lengths of lavatory doors now and be very worried that they're just trying to stop us from drinking while we're at work.
Yes, yes.
It's
That's
such
that's
an
why they
odd.
were invented. Yes. Yeah.
So I've got a couple of questions about the legislation and contextualizing it. So I'll start with the very broad one, and then we can narrow in. But was this colonial legislation? You mentioned the Victoria brought in a similar act the same year. So was it
Yeah.
being driven by changes in Britain?
Largely, yes, yes, yes. They had a number of factories acts in Britain beforehand, yes, and also in the United States they were developing industrial legislation as well, but very much had quite distinctive Australian qualities specific to Australian industry, notably the anti-Chinese clauses, which weren't seen in the British legislation. To some extent, it was seen in legislation in California. Uh, yeah, so
A couple of people have commented on the fact that you said it was a long piece of legislation at 14
yeah,
pages, which, if you've only sort of dealt with contemporary legislation or you've seen the Copyright Act, which I think comes in at about 700 pages at
yeah,
the moment, but it really was that is quite detailed for the colonial period, isn't it?
yeah. Well, I mean, particularly on this subject, that New South Wales legislators really didn't want to legislate anything on industrial legislation, and Victoria managed to get one passed. Initially, they got one passed in 1873, but it was effectively meaningless. It just had a few. I think it was about 3 pages. So that one didn't specify very much. There were no penalties for non-enforcement. The next one in Victoria, the 1885 one, that came in, I think, about 6 or 7 pages. That was that was yeah, quite short as well. But this one's 14 pages, and remember, it's New South Wales. They didn't like
A
to
few, yeah,
legislate. Yeah,
a few people are intrigued at the reports being anonymised, sort of potentially.
yeah,
There's an expectation that if those reports were made public, then yes, that data may have been anonymised. But you're suggesting that they were anonymised as they were lodged. Is that correct?
yeah. Well, I'm the factory inspectors would have the raw data, but when they compiled their reports, they anonymized everything.
Mm.
On the one hand, it was yes, it was to protect factory proprietors' reputations. It was also to protect workers in that factory inspectors try to encourage workers to report violations to them, and then if they would, record
Oh,
that
okay.
information, publish that information, of course, workers would suffer repercussions as a result of that, and wouldn't be likely to come forward. Yeah, so
So, a specific question coming off from that. Did the
mm.
factory inspectors report separately on the Chinese manufacturers, or were their statistics all rolled up with all the other stats that they were collecting at the time?
Yeah, it was all together. Yeah, yeah, and they had a section on furniture factories, and there was a European section. They use the term European, and a Chinese section. So yeah, it
Mm.
was yeah, all in together. I mean, they didn't. The factory inspectors. I mean, as I mentioned, it was all of Sydney industry, and the inspectors shared the Chinese factories at different times. There was no like specific Chinese inspector or anything of that nature. So,
Mm.
yeah,
This question is a little bit too specific,
yeah.
but I'm going to ask it anyway because it's just so interesting. So, did the
Okay.
factory inspectors interact or liaise in any way with the inspectors of nuisances at local councils, especially in the first 10 years of the Act's operation? Because, of course, the inspector of nuisances would often register complaints that had been made about factories that it was too smelly, or why were they doing ice cream on a Sunday, or whatever um, it was that a resident may have complained to their councillors about. Um, do you did you come across any of that in your work?
Yeah, yeah. The
Oh, okay.
the local residents would complain to the inspector of nuisance, who would then pass it on to the factory inspector,
Oh,
because that
okay. Oh, that
that
is
then
interesting.
fell under the responsibilities of the factory inspector to do that for factories. Yeah,
To follow up, very different
yeah.
sort of
But of
um,
but of course,
street.
yeah. So, I mean, anyone. I mean, the inspector of nuisances would have been within his rights to go into the factory and cite the Factories and Shops Act. I mean, it was, and the police could do the same. It wasn't exclusively the factory inspector who could do it.
Mm.
But it seems that more often than not, people were happy to pass it on to the factory inspector, because it was, I mean, a new area, I suppose. They didn't
Mm.
didn't want to
And
to
those
wade into
three
this.
inspectors,
Yeah.
what government department or agency were they actually employed under themselves?
Yeah, so they were in the Department of something. I can't remember specific Department of Labor and Industry. I think it was called
Okay,
Department of Labor and Industry at that time, but it changed names several times, and then
we still
they
changing
they put
Peter.
yeah, yeah. There were three inspectors initially, but of course they kept putting more inspectors on
Mm.
as the industry expanded. Yeah,
It's so interesting that um, quite a few of the things that we take for granted today, like access to lavatories and a tea room and all of those sorts of workplace, not even benefits, but just sort of basic facilities to enable people to work in a safe and healthy way are actually traced back to this legislation. But as you note, the progressiveness of it is undermined by some of the other factors of the Act. Is that a pattern that you saw in other legislation that you looked at of this time frame? That we could do some really great things on page 1 and 2 and then be actually quite horrible people by the time we made it to the end of a piece of legislation.
Well, if you compare the New South Wales legislation with the Victorian legislation, for example, I mean, the Victorian legislation had a lot more anti-Chinese clauses in it. Um,
Even though it was shorter.
large so the 1885 one was short. The 1896 one, they also legislated a lot more acts and amended the acts a lot more in Victoria. But the 1896 one was slightly longer, but that one had a lot more anti-Chinese provisions in it. And it wasn't that New South Wales legislators were any kinder than those in any more enlightened than those in Victoria, which is they really subscribe to principles of free trade over protectionism, and Victoria was a very a protectionistic legislature, yes, and also the influence of the labour movement was stronger in Victoria, and a lot of that anti-China sentiment was coming from the labour movement, but of course um, manufacturers were often very happy not to be competing with Chinese manufacturers as well. So the workers and factory bosses also had that commonality as well. They agreed on that point in many respects that they would agree to have anti-Chinese clauses in legislation because it suited both their interests.
You did mention while you were presenting that you compressed the complexity of the processes
Yeah,
having the
yeah,
legislation come to pass. But we do have a
yeah,
question around in your knowledge of the lead up to the passage of the bill.
yeah.
Was there an impression that you had that there was a desire to protect a particularly vulnerable group working in factories? Was there quite a movement, for example, to protect children or to protect women working in these spaces?
Well, the steam boiler to my understanding, was the main thrust. The original thrust was to get those steam boilers inspected and made safe. Um, I think so. Protecting women and children, of course. I mean that appeared in the legislation, but it wasn't that prominent, and I
Mm,
think that reflects the power of women and children in the labor movement at that time. It was a very male movement.
yeah,
It was and I think that men in the movement prioritized their own interests and
yeah. This is another interesting
largely.
question on gender. Um, did you see any indication in the research that you did that the female inspector, initially on her own and then hopefully not on her own, but did the women inspectors encounter more resistance when it came to having their recommendations implemented?
I expect that would have been the case, but I didn't see that evident in the factory inspectors' reports. Um, I think one thing I did notice was that the male factory inspectors were very seemed very grateful to not have to go and inspect lavatories, for instance, in a workplace where there were just women working. I mean, people had much. Well, it wasn't proper. It just wasn't proper in those days and so I think the men were quite grateful to be spared that
Mm.
responsibility.
And this is always the inevitable question at a Scholar Talk. What is next for you? I mean, you've obviously expanded on some of the work that you've done through your PhD as a fellow. Will this become part of a larger work on legislation of the time, focusing on the legislation or perhaps focusing on the anti-Chinese sentiment?
Um, well, I'm working on my draft currently for this. I'm working on a draft for a paper. Yes, and it's going okay, but there's like so many angles to take with this because these reports, in particular, are just so rich. And then I've got the Trades and Labour Council material, and then I've got the Chamber of Manufacturers material, and I've got the stuff that happened in Parliament. It's so multifaceted. I'm thinking of taking an two economic historians, one Andrew Seltzer, another is Jeff Borland. They wrote something about Victorian factories and shops and the minimum wage, and they argued because a lot of people have argued in economic history that the minimum wage legislation doesn't really do anything. It just reflects what's happening in the market. So if you pass a minimum wage law, it doesn't matter, right? But Seltzer and Borland argued, based on the Victorian Factories and Shops Act, that it did matter. It did make a difference. It did drive wages up in that case. So I was thinking something along those lines, but not in relation to the minimum wage. Something about factory safety and like the
Mm.
role of factory inspectors in in making change, driving innovation in factory safety. A lot of things to consider on this topic. Yeah.
Because where else are you looking for the archival materials that will inform your research? So you mentioned, of course, you've been using the collections here at the library.
Yeah.
Obviously, you would have used some of the materials out at State Records. Are there any other repositories that are helpful for you?
With this Factories and Shops Act, it's almost exclusively in state library. That's one of the reasons I chose it as a fellowship proposal. And so I have been out to state records. There's a couple of things, there's a few fire inspectors reports out there, but most of the stuff I'll be using is in the factory inspectors reports.
Hmm.
Yeah. Mhm.
Okay, well, if people don't have any more questions of Peter about colonial legislation, workplace safety, a couple of people did comment on the photos that you shared with us today, and it is terrifying that they actually did represent progress. So we have come a long way in some areas, at least. I would like to thank a few people because it is the last Fellows talk for 2024. Um, Often it's just me making the occasional television appearance, introducing a fellow, and then I get to ask them all of your interesting questions. But there is actually quite a bit that goes on behind the scenes. And my most heartfelt thanks go to Callum McLean. He is our stage manager. He helps me run the tech behind all of these sessions and inevitably saves the day when things go wrong. So while we have managed to always start promptly at 11 for our Scholar Talk series, some of the lead up to these presentations has not been over a nice cup of tea for a quiet talk at the library. It has really been much more like the trailer for a new Bond film, with lots of literally sprinting from one building to the next to try and get all the tech to talk nicely to the other bits of tech that then bring you a live event. So thank you to Callum. Thank you to Tanya Ali, who does all of the website work and makes it possible for you to all book for these fabulous talks throughout the year. Lydia Tasker, who is the head of our public programs, and of course, Richard Neville, because the fellowships program would not be possible without all of the efforts and the support of the Mitchell Librarian. I would encourage all of you to subscribe to our newsletters. You can do that on the State Library of New South Wales website. Just scroll down to the bottom of the homepage and you can see a little section that lets you subscribe to a whole bunch of our newsletters. But of course, I'm encouraging you to subscribe to the Researcher newsletter, which will be advertising all of our talks and all of the new things in research here at the library next year. Next year, Scholar Talks will be completely rebadged as Fellows Findings because they are all about the Fellows and our Fellowships program. We'll also be introducing a new on-site series called the Fellows Forum, which will be panel events where we'll pull together fellows past and present to talk about different aspects of research and focusing on different areas of the library's collections. I, of course, would like to thank all of the fellows who come and share their research on the first Tuesday of the month every year and at many other events here at the library. And not only do you see them on screen and on site, but I get to see them also in the chat. And I think it is a real credit to how the fellows collaborate and build a real sense of camaraderie that so many of their peers turn up event after event to engage with their research. And I will finish this morning by thanking all of you. Thank you very much for coming, for fabulous questions throughout the year, and for your commitment to the library and all of the programs that we run. Have a very safe Christmas and New Year, and I look forward to seeing you in February. Thanks very much. Goodbye.